the Ghana School of Law, has been referred to the Attorney General for prosecution breaches. The school was cited by the Auditor General for breaching the Procurement Act in the purchase of items worth over 300,000 cedis between 2021 and 2022. First, listen to the school's justification for going ahead with the procurement process without recourse to the law. I'll bring you details of that report later, but let me bring in my colleague James Kwesi, who is currently at the Public Account Committee, to bring us more details on this particular development. Now, Kwesi, let's start with details of this procurement. How many entities are involved?
Right, so in all, 17 entities have been engaged between the year under review, which is 2021 and 2022. And the business, the Ghana School of Law, did with the ranges between the procurement of toiletries, the payment of hotel accommodation for some members, as well as the procurement of chairs, tables, and other items within a 2 year under review. Now, the amount involved per entity ranged between, some went as low as 3,750 Ghana cedis, and others go as high as 92,000 Ghana cedis. Now, in the explanation given by the school authorities, they believe that since some of the items are not up to some 5,000 Ghana cedis, which the law, the procurement law, actually indicates that any procurement that is above Section 92 of the Public Procurement Act states that any procurement that is above some 5,000 Ghana cedis need to go through competitive tendering. But the school actually used sole sourcing to actually procure these items, which became the bone of contention. In fact, members of the committee, especially MP Frida Prempeh, who raised the issue, actually wasn't so happy with the fact that the institution we are talking about is the Ghana School of Law. People who teaches the law are supposed to make sure that the law is enforced. Breaching provision, and so she wasn't happy with that, as well as other members of the Public Accounts Committee were not happy with that. They the school actually make the point that this is their first breach. In the subsequent years after the auditors actually flagged this, they have been going according to the provisions of the Procurement Act, and so plead with the committee to actually forgive them and give them another chance to do the right thing.
Well, the matter was then referred to the chairman of the committee. What was his reaction?
Chairman equally wasn't happy. After the plea bargaining, I'll call it, between the school as well as led by the Director General of the Ghana School of Law, between him and the team and the Public Accounts Committee member, the chairman, together with his ranking member, will not take that. They say that, in fact, they have referred some cases that are less severe than what they have done to the Auditor General, and so there should be no exception to that. Therefore, moving ahead to refer them to the Attorney General. In fact, the Deputy Attorney General, Afrejai, was sitting right beside the Director of the Ghana School of Law when all of this was ongoing. And you could read from his book that he agrees with the Public Accounts Committee, especially when the chairman asked the question as to whether they have breached the law, and insisted that the law has been breached, and so the right thing must be done. You see Afrejai nodding his head to the fact that, yes, the law has been breached and the right thing must be done. Then the chairman actually referred them to AG to prosecute them for that procurement breach. It could be a fine from the court. It could some term of prison if they fail to pay the fine. Those are the prescriptions of the law on such cases.
We couldn't at the time.
So you are at fault. You have flouted the law.
Yes, we will admit.
Yes.
Unfortunately.
You admit because you have flouted the law and you have admitted, so we'll recommend you for prosecution.
Well, to err is human.
You know, you are the lawyers. We here, me, I'm an accountant. I'm not a lawyer. But the lawyers here will agree with me that this committee, even though when we sit at the High Court, we don't have that power to do what you're asking us to do. There's a body that is a court that might determine, the judges will determine that, oh, the plea you are giving will forgive you. So what we can do is to refer you to the court, that the court will set you free, because we don't have that power to do it. We don't have that power here to do it. We can only recommend you, then the one that has the power will say, listening to your plea, go home free and don't go and do it again.
Mr. Chairman, I think while sitting here, I have seen that you have given other people the opportunity to go and put their house in order. So you actually have the power. In order that...
those ones that I have given, the Auditor General did not specifically refer me to a law which must be applied. Right. Do you understand? We do. This is what the Auditor General said. Section 92 of Act 663 as amended should be applied. Right. And there, maximum 2,500 penalty units, maximum 5 years or to both. That is what the judge will apply. The judge will look at you and say, well, go home free, or pay only 1,000 penalty units, or go and sit and sound for 6 months. They will determine that. We will not do that. We have never done that.
Right, we stand corrected.
Yes. So we recommend you. Judge, clerk, take note. Okay.
Well, Aveji, we have also been getting some reaction from the Deputy Attorney General on the minority's position on one of the vetted justices to the Supreme Court. Tell us more about that.
Yes. So yesterday during the vetting, the minority actually took a position on the matter that, Justice Professor Opon actually has dual citizenship. He's a citizen of Canada as well as Ghana, and they took the position that he needed to renounce his citizenship as a Canadian before they would, approve his appointment. Other than that, they would have to oppose it. This is what I put to the AG, and he's of the view that there's been a ruling earlier this year, somewhere April, on this matter, allowing, judges to hold dual citizenship and still proceed over matters in Ghana's courts. That ruling actually banned at public office holders, including members of parliament. We know about the justice question issue and all of that. But the AG believes that as far as this issue is concerned, looking at the ruling that the Supreme Court did, April this year, Professor Opon is fit to take a seat at the Supreme Court as a judge, looking at that judge.
Yeah, that under our laws, you can be a dual citizen but still be a justice of the Supreme Court. At the Supreme Court in April this year, delivered a judgment to that effect. So the nominee who came yesterday is qualified under our laws, notwithstanding the fact that he holds a Canadian citizenship. But for the judgment in April, he wouldn't have qualified to be a Supreme Court judge in Ghana.
There are still those who hold the view that the Supreme Court actually did this in anticipation of the fact that there may be an appointment of this nature in the near future.
I have no evidence to that effect. It may be by mere coincidence, and people may conjecture, but there's no evidence to that effect. So let's leave it for now.
What do you say to people who say that it will not be fair to make members of the judiciary have dual citizenship to sit at the court, but members of the legislature do not have a similar?
Then we have to look at our laws once again. if as a people we think that judges must also not hold dual citizenship, then the law, there was an existing law, that judgment has struck down that piece of legislation. So if we think we want to open it up for others to come into the fray, let's look at it. As far as I'm concerned, the status quo now is that if you are a dual citizen, you cannot sit in the House of Parliament as an MP. Until that provision is amended or repealed, we should go by that. And also that if you are a dual citizen now and you want to be a Supreme Court judge, you are permitted to do so until and unless you repeal or something is done to that effect.
Part of your job is to ensure justice. Do the people of the legislature accept justice when they cannot hold dual citizenship and be in power?
Justice is about due process. Justice is about adherence to the laws. What laws are you talking about? There's a judgment to the effect that if you hold it, you can be a judge. So that's justice.
Country, if you follow his conversation, he hasn't prosecuted a case in Ghana before. He hasn't practiced in Ghana before as a lawyer. Was the guarantee that he would do due justice to issues that come to him from the Ghanaian jurisdiction?
Yes, yesterday you listened to him, you watched him. An excellent professor. He knows his stuff. In fact, we're in the law school together, even though he's 1 year behind me, and I know his worth. In terms of his ability to deliver as a judge, I can assure you, he has every quality that any judge should possess in the dispensation of justice, and I trust him that you do his job as a judge.
But I'm sure prosecution differs from jurisdiction to jurisdiction. If he hasn't had full knowledge about what we do here, will he be in position to deliver?
Fortunately, he's based in Canada, right? Canada is a common law jurisdiction. And so those of us who are called to the bar in Ghana, that's why we can appear or we can go to other countries. If you even want to practice, you go to some process that you can practice because we use similar procedure and similar laws. So there's nothing untoward about his knowledge when it comes to how he's able to do his cases in Ghana as a judge. Because whether in Canada, whether in UK, whether in South Africa, whether in Nigeria, Gambia, we use the same procedure. So there isn't anything much about it.